This session, the Directors Roundtable, allows me to remind you that Max Planck Law and this annual conference is still just new enough that we're establishing traditions together. As you know, we have the late start on the last day now, I guess, is one of our traditions, and the 1-hour coffee break is another tradition. Those are great traditions, I'll say, but maybe my fondest of the early traditions we're developing together is the Directors Roundtable at this conference. The aims of the Directors Roundtable is to bring the supervisors and leaders and organizers of the departments in which all of you work, these brilliant, excellent, and renowned scholars, together in an informal conversation. They do this amongst one another often, and it's a thrill to be able to share that level of informal dialogue with all of you around a topic that they've been thinking about themselves in their quarterly sessions. The theme that will bind them in conversation today is the question of what the future of foundational legal research should look like, might look like. And this setting our theme for the last several days, the emphasis in the Max Planck Society and in the Harnack House, its ethos itself, on foundational research. Our discussions about the future of law really make this an excellent sort of wrap-up discussion for our work from yesterday. That is, I expect we'll hear them to be talking about the kinds of values that will inform foundational research going forward. Professor Auer's lecture yesterday provided us an excellent framework in Rechtswissenschaft across the last 150 years as a background to the conversation, the forward-looking conversation we'll participate in and observe among the directors today. That would all be too much and too challenging for me, but luckily we have the help of Professor Anna-Bettina Kaiser, who is the chairholder of a chair in public law and general jurisprudence at our neighboring Humboldt University here in Berlin, to serve as the moderator of today's panel. Professor Kaiser has her training in Freiburg and in Cambridge, and she does her work most recently and in a celebrated fashion on the question of the Constitution in the state of exception. You can imagine, considering the policy and concerns facing all of us in the last year and a half, how relevant her work has become. But representative of our breadth of interests, she's also written on private autonomy, and she does a broad range of work at an interdisciplinary level. I have been immensely benefited by her work, Die Verantwortung der Staatsrechtslehre in Krisenzeiten, and I think that very soundly positions her for this conversation today. If our technology will do better than the technology at the conference hotel this morning, I think we should be able to bring our moderator and the panelists to the screen at this time.
Well, thank you so much for the kind introduction. A warm welcome to today's roundtable discussion also from my side. As Russell Miller has already mentioned, we will discuss about the future of foundational research. Let me introduce to you our 4 panelists. First, Anne Peters, Director at the Max Planck Institute in Heidelberg. Josef Drexl, Director at the Institute for Innovation and Competition in Munich. Christoph Engel, Director at the Bonn Institute. And Ralf Michaels, Director at the Max Planck Institute in Hamburg. The concept Grundlagenforschung, foundational research, is a hallmark of the Max Planck system. In the Society's organizational and promotional materials, the concept often is linked with a quote from Max Planck himself. Insight must precede application. So, at the very least, foundational research is research conducted without an awareness of its potential for application. You might say it is research that takes place behind the veil of insight and expertise. But even for the society, a more nuanced understanding of Grundlagenforschung remains elusive and evolving. In the immediate post-war period, foundational research meant basic research far removed from any political or business influences. Later, foundational research would be defined as innovative, interdisciplinary, cutting-edge research in established or promising new fields. The concept adapted to the increasing globalization of knowledge and research and eventually came to include an international dimension. That is, foundational research also should be anchored in and connected to the world scientific community. And it may have disappointed Max Planck, but the society has not been able to avoid ever-increasing pressure to produce applied outcomes. A recent communication from the society urged that basic research is and remains the foundation of economic innovation in order to accelerate the transfer of promising findings to potential applications. The ties between basic and applied research must be strengthened. How to respond to these various impulses in pursuit of the foundational research is the challenge of each of us. I have argued so far that the concept of foundational research is elusive and difficult to grapple. But it seems to me that this is particularly true for legal research. What does foundational legal research mean? The concept of foundational research was coined in the natural sciences. Does it have an equivalent in legal research at all? To bring the problem to a head, I would like to draw your attention to the concept of legal doctrine. Legal doctrine, dogmatic, is supposed to be the core of German legal research, but at the same time, it is said to be application-oriented by its nature. This leads to several follow-up questions. First, does legal research then have to completely detach itself from legal doctrine in order to be true foundational research? Mr. Michaels, despite these concerns, you have defended the concept of legal doctrine some time ago in the Verfassungsblog. Why is that the case?
Goodness, shocking. Thank you very much. Thanks for being hosting this. Russell, thanks for putting this together. Anna-Bettina, thanks for leading the discussion. No thanks for shocking me with the first question I'm unprepared for. Let me try this. Foundational research is always a challenge, as you already said in your introductory remarks. It's a particular challenge in law, right? To some extent, I remember when during my studies, a colleague said, I'm going to do research. I thought, you're not doing research, you're a law student. We don't do research, right? We open books, we look what's in them, we copy it into our Hausarbeiten, and if we do well, then we pass good exams and we become directors of Max Planck Institutes, but it's not actually research, right? So the first question in law would be, what is actually research, and then what is foundational research? And so often in law, we think there is kind of the superficial law, which is doctrine and cases and applications and legislations and arguments. And then there are the foundations somewhere separate from that. And some of those indeed we call Grundlagenfächer, foundational subjects like legal philosophy, legal theory, legal sociology, all of the things that first-year students had to get through until they get to the meat, to the actual law. And then you can do actual law, and the basic research is somewhere separate from that, and also somewhat irrelevant, right? Because why do you need to understand legal philosophy in order to know the requirements of a tort claim against a corporation or something like that? And the we think in law that that separation is actually itself artificial and insufficient. That means on the one hand, we often say, and the study reforms always say, that you cannot properly study legal doctrine without understanding some of the foundations. But I think the opposite is also true, and even more important sometimes. You cannot study the legal foundations without an understanding of the doctrine. And to push further, the core of law is actually in its application. It is the core of the law is what we actually do. I put that in a slightly different context from a recent chapter I wrote with a really brilliant legal anthropologist from the United States, Emily Riles, where we describe law as technique. And where we say the anthropological look on law has always been one with suspicion. To say law is actually just smokescreen, right? Law is just fancy tools and concepts that aren't really true. Corporations don't exist. Persons are just constructions of the law. So this is just all concealing some raw application of power. And that's odd because anthropologists see this making of artificial entities all the time, right? They research all kinds of practices without asking, is it really the case that taboo is an actual concept? Is it really the case that the spirits of your ancestors come back to you, right? And so they take seriously the actual practice of the law of practices as the deepest understanding of what those practices are. And on that level, at least, foundational research in law must also focus on the actual practice of law, and that is, to a large extent, doctrine and doctrinal arguments. That is, we must take seriously that that is the area in which our deepest problems, our deepest societal problems are negotiated and indeed also resolved, right? One of the advantages that law has over other sciences is that it comes to conclusions, right? We come out with actual outcomes. We come out with deciding the undecidable, as Derrida called it at some point. And on some level, that's a real advantage, but that does not take away the fact that in that core of that, we're still dealing with foundational issues and discussions.
Well, thank you, Anne Peters. A second follow-up question. Is legal doctrine, as it was described now once by Ralf Michaels, a typical German method? And if yes, does foundational research tolerate national peculiarities? Isn't fundamental legal research per se international? Plus, we're discussing the future of foundational research. Should the future of our research be more international?
Thank you, Anna-Bettina, for this unexpected questions. I can answer it, but I also have some reactions to what Ralf just said, if that's allowed.
Wonderful, that's wonderful. Would you start with the reactions?
Yeah, I think, well, what Ralf said, I have a bit of a, yeah, maybe I would like to add some nuance. So I totally agree that law being a tool or instrument to solve or respond to social issues, to order society, that law is, as Ralf said, in its core, the purpose of the law is to be applied. And therefore, all research, even if it goes to deals with quite abstract concepts and is therefore more foundational, is indirectly related to this application. And therefore, I would always say that even our foundational legal research that we're supposed to do in the Max Planck Society is indirectly also applied. And that corresponds, of course, to the insight that it's anyway a blurry, there is no watertight distinction between foundational and applied research. And in law, additionally, we have what Ralf mentioned, legal practice. So I see this really on a spectrum, more foundational research, more applied research, and then legal practice. And it's normally said that doctrinal research is more steered towards application, that the doctrinal arguments that are the immanent arguments made to understand better a text, they are directed at solving specific concrete legal questions and prepare a practical decision, for example, by a judge or maybe even by a legislator. So I agree that the doctrinal research is the most often on the applied, more on the applied side. Now to your question whether legal research must be inevitably or should be to deserve the label of research and to qualify as legal science, to use the Kelsen Germanicism, that it must be international. I think there is some merit in seeing the problem like that, because there is an established view that science must generate universally valid knowledge, and that it must also be in some way, the other thing, the temporal, the eternity of the findings is of course another problem, but universality in the sense that it must be able to be understood and reproduced by anybody, independent of the national position or social or cultural position and so on. I think that's an ideal which many people would say is the ideal of natural sciences, the reproducibility, the intersubjective comprehensibility. But of course, the law we are speaking about is man-made, and domestic law is tied to national jurisdictions. And therefore, if we study German law or French law or US American law, the subject matter is inevitably local. And I think that we can make scholarly statements which are intersubjectively comprehensible also by foreigners, even if they are about a local topic. That's not different from making universally comprehensible statements about, let's say, some ruins in archaeology, which are also local. Therefore, the local topic, national laws, and the universally comprehensible discourse, so there's no contradiction there. That would be my answer.
But no American would be daunted by that. So I would at least offer to Professor Michaels if he wanted to say a couple of words in response to that, and then I'll pose a couple of questions to the other.
Did we lose Anna-Bettina or what's up?
Yeah, I'm afraid we've lost her for the time being. We're looking for her in the Zoom universe right now.
Okay.
I apologize.
I'm happy to defer to others first. I'm sure I can come back and demonstrate where Anna is wrong.
I would turn a question then to Professor Engel, who some years ago with a fellow director of the Max Planck Institute for Tax Law in Munich, published the volume Das Proprium der Rechtswissenschaft, that is, the characteristics of legal research. The book was a critical assessment of the current state of affairs in German legal research at the time. And the opening lines of the book tell us what German legal research is not. And it says that it is not international, it is not peer-reviewed, it does not pay attention to impact factors, it does not call on researchers to make use of third-party funding, it does not involve math, I would say thank goodness. It does not involve statistics, interviews, or experiments. It's a pretty tough indictment back in 2007 that you had put together. I'm curious if across the years now you would issue the same charging document against German legal research, and if curing or remedying that list of shortcomings is the same thing as moving German legal research towards foundational legal research.
Well, that's not completely unprepared as a challenge, and I'm happy to give it a try. Of course, there's progress. If you look at it from this perspective. So we are getting more interdisciplinary, we are getting more international. You can see that if you look at the new generation of colleagues, they are much more open to all these things than they might have been some 15 or 20 years ago. Still, that quote isn't where I think we should deeply focus on. So I don't think we should lead this conversation as one of competition between runners-up and those who have already reached the goal. I don't think this is the right way to think about it. And let me exploit this opportunity to, in a way, say once more the same thing that the two colleagues have been said, and that may sound surprising to others in the room because I haven't been doing much doctrine lately myself, but I couldn't agree more. This is the core of our discipline, and rightly so. Why is that? Well, our job is an impossible job. We have to decide on problems, and if it goes to court, on cases that it's very easy to show can't be decided. Because in the normative dimension, we have to balance out normative concerns that a legal philosopher needs 5 minutes to explain to us are incompatible with each other. And on the factual side, next every practical case we have to decide is less founded on empirical insight than we all know it should be founded on. So we navigate a terrain as a discipline of almost impossible uncertainty. And still we do a reasonably good job. And the question is, how can we? And here is why doctrine is so important. Why is that? Well, human mind is able to do that. And that's one of the things we are very interested in at my institute at studying. It does so intuitively. And if later on we want to go back to it, I can explain a bit more how intuition works and how it differs from conscious decision-making. But the big concern with intuition is that it could be unguided and it could be perceived as irresponsible. And this is where doctrine has its key role to play, in that it guides and shapes the way how the individual judge or the individual lawyer more broadly approaches this conceptually impossible task. So I'm all for doctrine. Still, within doctrine or within legal decision-making more broadly, we not so rarely appeal to things that are either of a kind that could be made clearer conceptually. This is where we need the help of conceptual thinkers, could be philosophers, could be modelers. And on the other hand, we very often argue that things are of some kind and therefore the law has to be reactive or proactive in certain ways. So we make causal claims, and to substantiate these causal claims, we need the help from disciplines that are able to deliver. So this is why I think in terms of a division of labor between the practicing lawyer and academia, there is scope for what you could call foundational work, in that it helps those who have to solve these impossible tasks with giving them conceptual tools to analyze the task in front of them, and with giving them empirical backing that questions or supports the decision they're about to make.
I only
Anna-Bettina
stepped
Kaiser
in.
back. That's
I
why.
only stepped in your brief absence, so I'm happy to have you
No,
return.
I'm very, very glad. I'm very
Yeah.
sorry. It seems that Berlin Mitte is not well connected. I'm sorry. Anyway, I'm back, and I want to ask the next question to Josef Drexl. Your legal research on innovation and competition, especially emphasizing the role of intellectual property rules in those spheres, has a self-consciously applied dimension. Against your research background, is the problem of the application dimension exaggerated, like the divide of applied science and foundational science?
Thank you very much for the question, and also thank you for the organizers for allowing me to be part of this roundtable. Of course, intellectual property seems to be very practical in a way. There's a lot of application of the law. There are institutions that produce a lot of case law. And you are absolutely right that there are many, many scholars in the field of intellectual property law who mostly deal with practical issues and discuss the outcomes of decisions. However, there is another dimension to it, and I would say that this is more or less where we find our role as a Max Planck Institute, and this very well connects with what Christoph Engel said. Before it was said, the purpose of the law is to be applied. That is certainly true, but there's another dimension. There is a purpose of the legislator why certain laws are actually adopted. And that is, from the perspective of intellectual property, very utilitarian. There is, as Christoph Engel said, the assumption that the law has a causal effect, not only on courts and institutions, judges that apply the law, but on human behavior. And this is where the social sciences come into the picture, where we necessarily have to rely on other research in fields of, or other fields of research, be it technical, be it economic, be it psychological. So this is where practically nowadays, I can hardly think of a thesis that would not need to connect with other fields of research. So we seem to be very much the users of other fields of research. We have to take it into account in order to make decisions. Just let me hint at one very recent piece that we published at the Institute. We recently published a statement, very strange, very, very unique, a statement on a single court decision. And the decision comes from Australia. Very surprising. I think we never did this before. But the decision has very far-reaching, potential far-reaching implications for the future development of the law. And hence, even a single decision that applies the law and maybe modernizes the law against the modern technological background. In particular, the case was on patents granted for AI-generated inventions. We need to take this into account in order to actually direct the development of the law in an environment where technologies develop enormously quickly and where also the markets develop enormously quickly. And that is the real challenge there. And it's not only about applying the law. I think the doctrinal questions are enormously important. They are still very enormously important, and especially this decision had a very strong doctrinal implication. But the core relevance of doctrine is the rule of the law. We have to guarantee that courts and applications don't go astray from what the legislatures actually wanted to achieve and how the purpose of the law should be interpreted in modern times, even if it's applied, if the law is an old law that has to be adopted to modern circumstances. So I'm very much an advocate of PhD students in law that know about the law, have the doctrinal background, but they need to go further and take other disciplines into account. Whether they actually have to apply those methods, that's still another question. Where the results are available, I think it's better to leave it to other people, to other disciplines, to do good research in this regard, and rely as much as possible on existing research. But I have also supervised PhD students who actually did their own empirical research, for example, in particular. Thank you very much.
Yeah, I agree. I would also stress the importance of doctrinal research. However, I think it is problematic that some researchers write in their methodological essays that the doctrinal method is the same language that practitioners and researchers use. I think, yes, it is a common language on one hand, but on the other hand, it doesn't mean that we as researchers do exactly what the practitioners do. Because if that would be the case, we would have to ask the question Christoph Engel raised 10 years ago, some years ago, when he said, what is the proprium der Rechtswissenschaft? What is the essence of legal research? And if the answer would be, well, it's what the practitioners do, we would have lost our essence, I think. And my I would propose that we should differentiate between two ways of doctrinal work: the practitioners' doctrinal work and the researchers' doctrinal work. And there is an overlap, but it's not identical. But I have a comment by Anna-Bettina. Anna, please.
Yeah, I just wanted to jump in on what you said. Even if maybe the technique, the doctrinal technique in the sense of making arguments about how to understand a text and how to put one sentence maybe in context of the entire law or of a field, even if the types of arguments are the same when used by a scholar and by a legal practitioner, the context of making these arguments is completely different, and the roles of the two lawyers are completely different. The practitioner needs to find an answer and take a decision, is under pressure to come up with a solution, is not able to choose the issue that comes up. For example, the judge has to take the case which comes before him or her. Whereas the scholar is completely free, and that's the gist of academic freedom, to pick the topic, to pick the question, to put it in relation to other questions, and then to write his or her opinion about how to best to understand this or that law or this or that judgment. And the consequence of this scholarly writing will be not immediate in social reality. The scholar has no institutional authority. When I write that I want to interpret the Paris Article 9 of the Paris Agreement in a certain way, who cares? Maybe some other scholars might care, maybe practitioners might take it up, but I have no, there is no guarantee that anybody will care. But that's exactly, I think, the flip side, the necessary flip side of the academic freedom. It's in a way, in German, Narrenfreiheit also. I can write what I want. It can be also completely nonsensical. It will hurt nobody. And that's the big difference to the legal practitioner.
Ralf Michaels.
Yes, I mean, first, Anna is, of course, not right to say that she has no authority, because she is one of the most highly qualified publicists of the various nations. And therefore, under the ICJ statute, she is a source of international law. So she certainly has that authority. I think, Anna-Bettina, when you say practitioners and scholars, in a sense, use the same language, but it should be different, there's a way of understanding, I think, the difference between foundational research and applied research in thinking what we do when we arrive at Berlin Hauptbahnhof and we want to get to the Hanakhaus, right? So what we used to do was we would open a map. We'd have a city map of Berlin. We'd look up how we get to the Harnack House and we get there. And what we do now is we open our phones and we ask it for directions and it finds directions. And in a sense, that's the difference between foundational research and applied research. The applied research says, how do I solve this particular case? How do I find a drug for a particular disease? And the foundational research used to lay out the background against which this could be decided. So we had mRNA research, which was foundational research, and which then leads into applied research very quickly to find a vaccine against COVID. We used to have city maps as foundational research, and we would, on that basis, be able to develop actual specific ways. And the task of the foundational research, of the basic researcher, was to provide the city map. And in a sense, if we go into funding, third-party funding tends to be applied. It wants us to find solutions to particular problems. And our task as foundational researchers who do not rely as much on third-party funding is to do that which does not require that, which is provide city maps. At least that's what used to be the case, because of course today no one has city maps anymore, right? So everyone just uses the internet, uses the big the data solutions to provide only applied solutions. There may be something like a city map in the background of the algorithm, but we rarely have access to it and we rarely need it actually as a city map. It can produce it for it if we need it, but we don't actually need it for any particular task. And that, I think, is a threat also for the foundational research that we do, that at some point the practice of the law takes over, so to speak. So when I said before that, of course, the practice is the core of the research, it nonetheless used to be the case that we have to provide the universals that underlie it. The challenge, I think, is that those universals may no longer be there. That is, that practiced law no longer relies on the kind of foundational research that I named, and the foundations themselves are no longer there in a pluriversal world. And that, if to speak about the foundational research of the future, is probably the threat. In the 18th, 19th century, Marietta Auer talked about it yesterday, you could provide grand images of what the law actually is, or what epistemologies of the law actually would be. And the threat might be that we no longer have access to that in a highly fragmented world, and in a world that can render its decisions in other ways than by going back to the foundations.
Of Engel with the last remark, and then I would like to move on to a second topic. Christoph Engel.
You put the toughest problem at the table, which I think is not, should the law do away with doctrine? Nobody would argue for that. But what should a legal researcher do? And do we want them to be the backbench of legal practice? Do we want them to be outside observers, completely dissociated from legal practice and undisturbed by the daily needs of practice? I guess either of these extremes is not what we want. Ideally, there is division of labor, but mutual relevance. And yesterday we talked about a little bit, is the US system going the right or the wrong way? And I think this particular question invites comparing to the US. In some respects, I would still argue the US academic system is ahead. So in my own work, if I look at empirical legal scholarship, most of the colleagues I talk to are in the US. But if I look at the workings of the interaction between the legal practice and legal academia, one can have the impression that practice really doesn't care a lot about this excellent work that's being done at first-rate law schools. Whereas in Germany, they still seem to care, but they are less sophisticated. So how can we strike that balance? For sophistication, we need a certain degree of specialization. And that's the biggest limitation of the German legal system, because our law faculties are relatively small. They can't afford having specialization on things that you would need to be active at international scale. On the other hand, the very fact that the law schools are in Germany pretty small means they can't afford dissociating them from legal practice. And I'm torn between those two. So maybe the German solution in the end of the day is even preferable over the American one, despite the fact that the technical quality of some of the work that comes out of our system is not living up to the highest standards.
Well, thank you so much for our first round. I now want to go on and to discuss several threats to foundational research that could become even greater in the future. First, I want to address the dependence from third-party funding that seems to endanger foundational research, and that was already mentioned by Ralf Michaels. Why would I say that third-party funding endangers foundational research? Take the example of Berlin. The Berlin universities, the so-called Berlin University Alliance, BUA, was successful in her application for the status of excellence at the DFG, the German National Fund. However, the BUA distributes the money by way of calls. She organizes so-called grand challenges and is the agenda setter. It is her who sets the research topics. To be sure, the Max Planck Society is the island of the blessed concerning the pressure of third-party funding. But the idea of the need of third-party funding seems to have reached the Max Planck Society too. How do you evaluate the risk to foundational research, Mr. Drexl?
Thank you. If I may react to your observation, of course, at our institute, this is definitely a big issue. We are the blessed, and we have to value the independence of the Max Planck Society. We are concerned, however, because of course in our field of research, the interests are huge. Because there are major firms, multinational firms, that invest enormously, other science institutions, university centers, and so on, in the field of our research, especially in the digital sector. There are research institutions that are financed by Google or Facebook, or also Qualcomm in the field of patent law, and they have very, very strong vested interests. So this is definitely a very huge problem, and it's very difficult to go around with it. I'm also a member of the Bavarian Academy of Science, and I was a speaker of a top research group, especially on that topic, on how can we actually build trust in sciences, and dependence on third-party funding is an enormously problematic aspect. And transparency plays an enormously important role. And many things are not going the right way. I just give you an example. I have, in the past years, I have participated in a European joint doctorate financed by the European Union. Part of that scheme is that the universities actually get in touch with partner organizations from the industry. The idea is not a bad one in the field of natural sciences, because the idea is that the researchers actually go to private undertakings and do research in the labs, and may also, maybe after the PhD, be hired by those firms. However, for us, it was awful, because we had to reach out. We were told we are not allowed to only cooperate with industry associations. We needed to cooperate with individual firms. And then people went into those firms and had huge problems, because there was, of course, people there, in some instances at least, tried to influence the direction of the research. And that's not acceptable. It's simply not acceptable. Law has to play the tune of public interest in the first place and not of individual interests.
Thank you so much. Another idea stemming from the Anglosphere is the so-called third mission, even though the name seems to be an artificial word. Third mission in a German context means that knowledge that was gained by research should be transferred back into society. The concept, as I understand it, is not about application, but about communication. Thus, for example, at Cambridge University, a researcher is expected to write a popular version of her research, and the same now becomes true for Humboldt University. However, one could ask whether foundational legal research has always to be interesting or understandable for a larger public. Ralf Michaels, do you agree? Is the pressure to communicate a danger to foundational research, or is it really necessary to have a link between society and the researchers?
Well, I think there are two aspects on that. One is the question of the link, and one is the question of the communicability. Let me say a point before, just on the third-party funding problem, and then come to your point. One challenge of third-party funding, especially if it's privately funded, is that it provides the specific questions to which you have to respond. And foundational research is mainly not finding answers, but formulating questions. The main thing we do is to determine what actually should be researched, and then we research it. It's not responding to questions. That is pure application. The second problem with third-party funding, and that's also in public third-party funding, is that it tends to be essentially backward-looking and conservative. That is, you have to lay out a plan on what you promise to find before you have found it, right? Which is why some people suggest that you write your applications for third-party funding when you're done with the research already, and then you use the money to formulate your next third-party funding application. Because you have to write 30 pages on a project, including 5-year plans to say, here's what I'm going to do at year 3, year 4, without even knowing what you're going to find. So in that sense, foundational research cannot be third-party funded in that particular way. Okay, now to the question of communication and links to society. I would say that on a broader level, of course, everything that we do in research, also foundational research, we do with a great responsibility to society, in part because we take society's money, and in part because we engage in a society to which we are responsible in our jobs. And so that link in a broader sense always has to be there. We also have to be aware of the particular situatedness within which we do our research, the conditions under which we do research, because they tend to shape our research and their fundings. So in that sense, that third mission, as you borrow it from the English situation, is always a part of what we do. Communicability, I would say, comes in at the end at some point. What I research has to be communicated back to society, but it's not actually a threat to the foundational research, because certainly in our fields, maybe it's different in the natural sciences, certainly in our field, if what we find is not communicable, then we haven't done the research all the way through, right? If we don't have the clarity that we can explain, then we don't have the clarity of what we found out. As I said, in some natural sciences that may be different, there are very complex mathematical propositions that ordinary people like myself can't understand. But if the law is not clear, then the law is not proper. And if our research cannot be communicated in its essence to a general public, then our research itself is not done and is not of value also independently of that communication, I would say. And I struggle with that communication myself sometimes, and so I also pose that as a requirement on myself.
Anna-Bettina.
Yeah, just a short follow-up. I totally agree with Ralf, and would like to link to your first question to me, namely the international communicability. I think that communicating to an audience laypersons and professionals who are socialized in a different legal culture is also such a test, like doing a communication to the lay public in the third mission. I would like to use the term fundamental rights, Grundrechte als Eingriffsabwehrrechte. I can't explain that to any Anglo-American legal scholar or lawyer. And I think this should make us reflect also about the value of such concepts. If we boast ourselves as German scholars to be so sophisticated, but if we are not capable of explaining that to somebody who is not socialized in our system, I think we should have additional thoughts on that.
Sorry.
I think, though, just to throw that in very quickly, there's of course a high level of technical capability that we study at law school and that practitioners need, that lay people do not need to understand, in the same way in which we provide engineers with particular capabilities that lay people don't need to understand. I don't need to understand how my computer was built in order to be able to utilize it. And in that sense, some of these concepts that Anna rightly criticizes might have their justification within a system, although she's also right to say if we see other systems can work without that and can, then maybe these are not as essential as we tend to think as lawyers. I think that the communicability and the link to society happens on a broader level. So the computer, the builder of the computer does something that I don't understand. But if I don't understand how to operate the computer in the end, then the computer has not been built very well. My our recent research on child marriage here at the Institute has a lot in there that relies on sociological findings that we ourselves borrow and very complex legal doctrines in different countries that others would not have to understand. But the outcome of that, the assessment of the way in which a child marriage is constructed by the law, treated by the law, etc., that I think needs to be communicated. I don't think that's different from what Anna had in mind.
I have another question to Anna, and that is the question of ideologies. I recall that we are now talking about the dangers to foundational research, but maybe also the chances, talking of the third mission, but coming back to the dangers, ideologies. We see rising and falling political ideologies, even in our neighboring countries, and think of Wojciech Zadurski, a Polish constitutional lawyer that is even threatened by the Polish government and sued. And so will this be a major problem if we, and that's the topic of our conference, if we look into the future, will this be a major problem and how do we cope with it? Anna.
Okay, ideology. What is an ideology? Ideology, to have an ideology is a negative, has a negative connotation. When we say that populism is an ideology, then it means that it's something bad. But of course, we all have ideologies. Liberalism is also an ideology, and anthropocentrism is an ideology. Law.
One could say maybe against pluralism.
Yeah.
Pluralism. Convinced that you are found the truth.
Yeah. Okay. So that would be then an attitude which is fundamentally opposite to the scholarly and scientific mindset, because I would say that the essence of scholarship is that to try to generate knowledge, which is open to criticism, which invites criticism, so that others may build on it, may refute it. So the scholarly activity is exactly the opposite of the ideological closure, as you now said it. On the other hand, the law which we were speaking about the law in society, I think, and I think that this is also mainstream, which most people would accept, that our legal norms are no hermeneutically sealed off construct, but that they should reflect and do reflect the values, or not to avoid that term, the ideas which are prevalent in a society, while at the same time maybe contributing to shaping also the flow of the ideas. And it is also normally said that public law, including public international law, is somewhat closer to this sphere of politics / ideals. I think this is only a matter of degree to private law, which is of course also eminently shaped by ideas about how a good society should function. But the private lawyers on the panel might add to that. So inevitably, dealing with the law and also researching in the law will have to be connected to such ideas about society, also about a good society. Because as I said, law is not just a technical sealed off sphere of normativity of its own. And therefore, I think that ideological, or maybe to put it more neutral, ideational arguments will flow into the scholarly investigation. And I also think that this does not necessarily damage the scholarly quality of the activity as being scholarship, as opposed to pure politics or pure ideology, because it is inevitably, and it's a matter of degree, that the primary purpose of the researcher is to examine a legal issue or problem from various angles, and also to keep some distance from the topic, but inevitably, even for the most doctrinal activities, like identifying the meaning of a certain legal text by looking at the purpose, which Christoph Engel mentioned, and so on, the ideational, the convictions of the scholar will come into the picture. And yeah, as I said, it's not a bad thing. It's even a good thing, as long as the researcher is also kind of open and self-reflective about that. But maybe that's not the answer to your question. I think your question was more that in the future, we have to deal more with polarization in society, and that people are more ideologized and so on. I think that this is a current situation of overall anxiety against globalization in all its forms, including economic interdependence, anxiety about losing one's job due to competition in China, anxiety about ecologic degradation, anxiety about global warming, and also anxiety about losing cultural identity because everything is McDonaldized and so on. I think this is the overall atmosphere, the overall intellectual atmosphere in the world, of course, to different degrees in different regions of the world, but a sentiment which will surely grow. And at the same time, also due to an overflow of information and complicatedness of our world in terms of technical issues, as Ralf just mentioned, people kind of, I think, tend to resignate and think it's impossible to understand anyway, and therefore, combined with echo chambers in the different types of media, it's a hostility towards the possibility of knowing something in an objective way. It's doubts about being able to understand, and this leads to this overall like post-truth era and anti-scholarly, anti-science attitude, which is then exploited by populist leaders. So this, I think, is a phenomenon and an overall situation with which scholars have to reckon. And this makes what we just discussed before namely communication and knowledge transfer to society, all the more important. The more science closes itself up and seems to be something which is incomprehensible anyway, the more it will lose legitimacy.
I look at the panelists and wanted to ask, especially Christoph Engel, do you want to add something to the discussion we had?
I'm happy to. And maybe raising two provocative names here. Nobody seems to believe in Judge Scalia. Nobody seems to believe in Kelsen. So historically, there have been ways to deal with the ideology problem. Scalia says, it's not for you, you are the servant, it's the historical legislator whom you have to interpret, period. Of course, a very conservative program, and of course, he was trying to hide behind this, but at least you can come up with the idea. Or Hans Kelsen, who said, there's a big divide between the practicing lawyer, that's dirty stuff, and academia exclusively has to care about consistency. We should not even consider that this has any outside effect on reality, because that's none of our business. This would make us politicians, and that's not what we want to be. I find it interesting that these historical counterpoints to the danger of the legal scholar being a disguised politician are not even present in our debate. Actually, personally, I would not go into the Scalia or the Kelsen perspective. I think we have good reason to engage with the political problems of our times. But at least as a reflective background, we should be aware of the fact that this is a choice and that disciplines, the legal discipline could organize itself differently. And actually, not so much Scalia, but Kelsen was very much saying, and that's the condition for us being a science. So I at least wanted to flag it out so that we know what we are doing.
Okay, I would like Josef Drexl, I'm sorry.
Thank you. Of course, there's the question to which extent we are allowed to have our own political opinion. Since you mentioned the case of Poland, I just came about a new book written by a young Polish scholar who wrote on the influence of populist governments on the practice of competition law in EU countries. And his test case, of course, was Poland and Hungary. So you can also see that scholars react to populist movements. And that's probably, I would say, the book that we would like to see, right? But of course, already the research question is an enormously political one. And I wrote to him, he informed me because he did his research partially at our institute, and I knew about his book coming out, and he wrote to me to inform me that it is now out. And I praised him for taking the courage, because that is endangering his own career. That's very, very obvious. I think to a certain extent, we are allowed to have our own political opinion and also to fight for certain values. I think that is even part of our legacy, especially here in Germany, that we should not be blind against what you called ideologies are doing with society. We have to play a much more foundational role in this regard for modern societies, to also pinpoint when things absolutely go in the wrong direction. And of course, on a lower scale, that is equally true. I think we need, what I tell my own student, be very clear when you are making judgments, that you are clear about your values, on what are the criteria for making judgments. In that field of making legal arguments, I think that is a kind of discursive evidence, meaning that we can try to convince others, but we can only do so when we inform others in our writing what our arguments are and what our value system is. Others may share the value system, yes or no. That is a secondary question. We are not the legislators. We are not the judges that have to make decisions, but we can take part in the larger discourse. And in this regard, I think it's most important to be clear where we actually stand, and then it's absolutely fine.
Well, thank you so much. I want to move on and want to discuss your research. In what way will the future of foundational research differ from today's research? You've all set up programs for future research. To what extent do they reflect your vision of future foundational research? Ralf Michaels, the MPI-Hamburg has been a leading center for the theory and methods of comparative law. If there has been any approach to legal research that held out hope for scientific character, it has been the comparative law discipline. But that remains a disputed ambition in the discipline. Your new project on decolonial comparative law seems to be a courageous response to the long-standing critique that comparative legal research is preoccupied with and dominated by the so-called global north. What other blind spots in the tradition of legal research must be accounted for engaged in future foundational legal research?
Yes, thank you. So that is indeed a question that was in the memo before, but that I decided I have no answers to because it is too comprehensive to talk of all the other gaps. I'm glad I identified one, and decolonial research, and can take that on at least. But maybe I'll try and maybe link to the last discussion about ideology. I was happy with what all three said, which is that first, of course, ideology is unavoidable. And second, we have to be self-reflective about it. And third, what we aim for is not to be non-ideological. Scalia's suggestion that judges can be non-ideological, and that's by going back to original understanding, that's itself a deeply ideological position, right? And it's problematic because it is an ideological position that pretends not to be an ideological position. So what we must aim for, I think, and that's what Josef Drexl rightly said, and Anna earlier, is intersubjective communicability, to say we have to develop ideas in which we lay out what the framework is and what conditions they exist and which are communicable to others. I would think that as concerns, of course, everyone says that the foundational research of the future will be what my foundational research of the present is, right? What I'm doing now is what everyone should be doing in 20 years. But I would say maybe as an addition to Marietta's proposition yesterday that legal thinking always orients itself against leading broader epistemologies or disciplines of the time, and that would remain economics. I think one of the leading challenges is the end of humanity due to climate catastrophe, right? Leave that aside. Other than that, one of the big challenges I think we find, and we're finding in Germany also, is what you just mentioned, which is global North universalism and a decolonial, post-colonial struggle against that. And I would say that that is a deeply foundational challenge to our legal thinking. So one of the things that we tried to do, Anna mentioned that in the beginning in science and academia, is to find universals. She stepped away from the idea of universals over time, but certainly the hope was always to find universals over space. So we can find the essence of law somehow by looking comparatively and finding what law is, what kind of the basic elements are that we find everywhere. So to say law itself may be domestic and contingent, but law as a foundational subject is universal. Now I would say, on the one hand, law is global in the sense that we have effectively we have a global legal system. We have an interrelatedness of all legal issues really, because society is global. And so in that sense, that what used to be just the domain of comparative law has become the domain of law altogether. We can't do any law without a view of the global. But on the other hand, secondly, we realize how pluriversal this society, this global society is, and how pluriversal law is. That means we can no longer set our own contingently established doctrines, concepts that we have developed in Europe, in the global north, against a very concrete contingent history of Christianity, of economic success, of colonizing others, of specific developments of secularism, etc., and universalize that and claim those are somehow the benchmark for the rest of the world. So we know that that is true for epistemological reasons. We know that it's also true for moral reasons. So in that sense, a challenge clearly is to become pluriversal in that sense, to take back this claim for universality. And the second that is really also related to that and is related to coloniality is the deep power imbalances in both economic and political and indeed epistemological terms, in which a global north tends to dominate a global south. And so it would not be enough to suggest that there are alternative concepts of law elsewhere if we maintain the kind of ranking in which we no longer universalize our concepts, but we put them at the top of the ranking, so to speak. So that seems to me the deep challenge for foundational research in law. It's such a deep challenge because it runs precisely against the instinct to say what we want to do is find universals. The instinct has always been to find universals, and maybe all-encompassing universals that can take in the rest of the world. And the challenge now is to say that it's this very aim at universality that is a threat to proper ways of both understanding the world and governing the world. And so that, I would think, is one of the core challenges to our legal thinking, and it's one where I think foundational research has to provide a basis on which that kind of pluriversal legal thinking, as we call it, would become possible.
Mm-hmm. Anna, I saw that you want to comment on this, and I'm very happy on that. But since we are running out of time, I would ask, would you combine your comment also with maybe an answer to your research, because I want to present also your research to the group. And you have pioneered in the field of, and that fits perfectly well now, global animal law, as opposed to merely national or even regional frameworks addressing animals. You've argued that animals should benefit from legal personality, just as corporations do in domestic law, and as humans have come to enjoy that status in public international law. You argue that legal personhood is a purely technical juridic device, a legal fiction. Still, humans and even corporations are human-centered fictions. Would you say that the future of foundational legal research requires us to rethink and break with law's anthropocentrism?
Yeah, thank you for that question. Actually, just one note of caution. I don't think that I wrote anywhere that I think that legal personality is only a fiction, something which can be established at whim. I said that this is one approach, but there are also other approaches, of course, and I think that the quarrel about legal personality is exactly so deep because it is not something which is just volitional, which the legislator or a court could posit at whim, but that this concept, and maybe this is true also for many other legal concepts, carries a historical, cultural baggage. For example, personhood or personality has been debated in theology, in philosophy, and so on. And the legal concept, even if we say, okay, its meaning in law is specific, it somehow feeds on this historic pedigree, and it cannot just simply shed it off. So this is now again against Kelsen in a way, and that the impossibility of shedding off the historical baggage explains why people get so upset when somebody proposes legal personality for animal, however positivist they pretend to be. The fact that they get upset shows that it's about something more. But I would, as a important future method or outlook and approach to law, I totally side with Ralf concerning the challenge against universals. And in my field, international law, this is of course much more stressful, because international law by definition is a legal order or legal system which claims to set the rules which are valid on the whole world. That's what international law is about. I think people dealing with German law or with US American law have much less problems because they don't have a claim towards universality. They just say, okay, this is valid for Germany, it fits to the German culture, etc. But international law wants to regulate the whole world. And I think that it also only makes sense if we have one international law and not if we have a US American international law, a German international law, and so on. So the challenge now posed by subdued nations of the South, by the problem of imbalance of power of states, presents itself in a very practical and very real way to international law. And for me, it's interesting to observe why now, today, this debate has come up, the debate that international law is not really international. And I think it has come up because of the power shifts in reality, that the formerly dominant European transatlantic, the powerful aliens which set the rules and which expanded them in the world, they had been in historical times, from time to time, attacked. For example, in the period of decolonization in the 1950s and 1960s, there were formations of states which were then new, former colonies, which said, we don't want to accept all your European rules, which you imposed on us. We want a new international economic order. We want a clean slate against the treaties in which we were caught when we were still colonies, but they were not successful. They were just, they made the arguments, but they petered out. And the reason is that they were no powerful players. And now they have powerful spokespersons, for example, China, which claims to be the speaker for the developing world, which also claims to be a developing country in order to benefit from some rules which are only in favor of developing countries. And because of this power shift, we now have to listen to them. I think on a meta level, this is also an interesting insight, namely that the legal debate is dependent on the power constellation in a very hard way. We now listen to them because we have to. And also there is an intellectual undercurrent. I mean, this whole post-structuralism, deconstructivism and so on, which also then led to post-colonial and third world approaches. These arguments have been made in the 60s, 70s, 80s, 90s, and so on. And they have been made by scholars in the Western world. And they have, in a way, increased our sensibility towards these positions of the subjected, of the underdogs in the international world. And now the rising underdogs are equipped with an intellectual arsenal, which has become not mainstream, but quite powerful. And this, in addition to the economic, etc., political power shift, lends more force to their arguments. So I think it's not only about the material substructure, but it's also about intellectual power. However, I think the danger is that these, let's say, post-structural arguments, they will lead to, in a way, they throw out the baby with the bathwater, and they lead to undermine normativity as such. Because if it is extended to everything, that all normative claims are only dependent on your position, whether you're on top or at the bottom and so on, then this will be the complete end of any possibility of normative order. And that does not do a service to anybody then, I think.
Yeah, please forgive me that I don't jump in here, but instead ask Christoph Engel and Josef Drexl about their research and outlook. Mr. Engel, you're one of the very, very few in German public law, you said it yourself some minutes ago, who work with experimental research and even laboratories. And you mentioned before that most of your colleagues you talk to come from the US. Do you see this kind of research as a growing field in Germany?
I couldn't say anything, but I very much hope so. And actually, quite a few people now have come out of the institute, and many of them have embraced the methodology. So I would be optimistic that we get more of it. But I don't want to come across as somebody who has just wedded himself with one methodology and now wants everybody to become an experimentalist. This would be pure nonsense. What I think we in academia, and especially in the Max Planck Society, have as a great privilege is spotting a great opportunity for the discipline, which in my case has been the behavioral underpinnings of both the problems the law wants to react to and the way how the law actually can make a difference. And there's still a lot of things that can very productively be done, which is why I am pretty confident that this exercise will go on. But whether this leads to a change in the way how foundational law is done, I would be very hesitant to make that claim. I would rather say each generation has to find the new opportunities, and there will be people who embrace them. So the next opportunity beyond lab experiments is very likely much better understanding in which ways machine learning and the law are interacting. Actually, we are moving into that at my institute. So things like we have the legal solution for the individual person that differs from the legal solution for another individual person. We may even conceive of taking the human out of the loop entirely and have the machine make the decision. I'm a bit skeptical how far we can go in that direction, but at least there's considerations that go into that direction. There may be a reflective loop we haven't had on our screen sufficiently, that if society moves more into that direction and the law exploits these opportunities, this may change the way how members of society perceive the law and react to the law. So I think that there is a great opportunity, partly scary, I would add, but at least a good topic for a next generation is certainly out there. Let me conclude on one institutional question. I alluded to it earlier on. For any of these new avenues, you need enough of time, manpower, resources to do it well. And that is something which our German legal system is not doing as easily with as other legal cultures or other legal systems. So to stick to this intersection with AI for an illustration, you need a working collaboration with a good computer science department. You need to train a whole generation of people on being down to the earth of programming, just able to see what's going on and maybe change things. So that's not something which a Lehrstuhl can do. And I think we have to rethink the organization of the academic system, or the German contribution will usually be one that comes a couple of years later. And that would be, given the high potential of what this country is able to do intellectually, a real pity.
Josef Drexl, that fits very well. Is the future of foundational legal research necessarily more dependent on technologies that permit contributions from AI or use of vast data sets?
Well, that's a good question. Actually, our economics department is already using digital technology as a research instrument, including machine learning, to actually, for example, to actually compare or let's say they are using text and data mining technologies and the analysis of large volumes of literature, identifying how certain innovations actually occurred over time, right? That is what you can actually do by hiring people in the field, and they are now doing more maybe computer sciences than economics in a way, but just to actually show how innovation occurs. So that is already happening in legal practice. Of course, that is what Christoph Engel said. We already see the advent of AI tools and so on. Legal tech, it's a big issue, of course. Concerning more the challenges for our legal research at the institute, I think that the challenges have never been greater. To put it in just one term, it's due to radical change. And radical change has basically two aspects for our research. The one is technological. We are seeing enormous the advent of multi-purpose technologies. AI is one. CRISPR-Cas in the life sciences is another one, which can be applied for many different fields of research and markets and products, and it's revolutionizing sciences and also the world we live in. We have to say this with enormous implications for our own daily lives, especially in the digital sector. It's obvious to everybody. And the other one are huge humanitarian challenges. The pandemic is just one. Climate change is another one. Growing world population, feeding the world population is another one. And what you hear now everywhere, innovation is the solution. And this is certainly exaggerated to a large extent, but you have it everywhere. It was very much part of the election campaign we have just seen in Germany, where politicians believe in the capacity of innovation as a problem solver. And then, of course, the next question is, what is the role of the law? If you assume that our fields of the law, intellectual property and competition law, are actually the legal instruments to create incentives for innovation, right? And all those laws are pretty old and maybe outdated. In competition law, digitization is currently questioning the foundations of competition law. How shall we adapt this? And then you get politicians who ask you, how shall we actually reform the law in view of all this? And you have to give the answer from today to tomorrow. And first we need to understand the technology, for example, AI, to really provide informative information on how the law has to adapt. First, you have to understand what AI actually means, what the input for AI is, for AI development, what the elements of AI are and what the output is, and you need to translate this for lawyers, because we are lawyers. We only have a limited understanding. Ralf Milches mentioned this. What do we need to understand? We don't need to have programmers. We don't need to train AI ourselves, but we need to understand the basics for our legal purposes and think about how the law should adapt. And this has to happen with enormous speed. And when we are saying, hey, wait a minute, we can't tell you so quickly, good research also needs time and needs time for doing research, to speak to people who can inform you, to have workshops and so on. This is an enormous challenge. But just to mention, if you want to focus on empirical research, what do you do in such a situation where things are just about to happen and you don't know how this actually changes markets? We have now tried to find out how artificial intelligence is changing markets. We are not really there, right? We still, it's very difficult to tell what are the fundamental changes. We will only see this maybe in a couple of years, but we already need to be prepared now and to give advice for very concrete legal questions that are on the table relating to AI. And that makes it enormously difficult, but also fascinating. I have never seen such a fascinating time during my career as we have it right now.
Thank you. We are well in time, and we are now starting the question and answer session with the auditorium. I have a question to Russell. I can very well see, of course, here in the online session who wants to say something, but I can't see anybody in the Harnack house. So I need your help.
Yes, I'm here at the podium, and we have 2 assistants with microphones to move around the room. So I propose we collect a couple of questions here in the Harnack house. They should be audible to all of you online as they pose their questions, and then we'll watch the chat function here online as well. If you don't mind keeping an eye on that, we'll split virtual and in-person responsibilities at this point. So let's see if there are some questions here in the hall. Yes, we have a gentleman here. They'll take a couple of seconds to get the microphones over to those.
So first of all,
okay,
many
yes,
thanks.
so we have the first question.
Okay, should I start?
Yes, please.
Yeah. Many thanks to the speakers. I was wondering that Professor Drexl and Professor Engel mentioned clearly that no matter if you are working with applied research or fundamental research, you need interdisciplinarity. And there is no way that we can escape that. But I was wondering the position of 2 other directors on that. Do we differentiate fundamental research from the applied research by saying that, okay, fundamental research is inevitably interdisciplinary, but applied research are using more doctrinal method? Or if not, then what's the role of the doctrinal research in the applied and fundamental research? Thank you.
I propose we take both of the questions from the hall here and then allow the panel to respond. So the second question.
You all hear me?
Yes, please.
So I actually have a couple of questions, if I may, but I can keep them brief.
Okay, we'll see how long the first one goes.
Okay, sure, I got it. So my first question is about what role you think the sociology of knowledge and the theory and philosophy of science can play in settling some of the questions that you raised. So when we talk about foundational legal research, I think the question that we need to answer first is what it means for law to be a science. And as we heard yesterday in Professor Auer's lecture, that question is not new, but culminated around the turn of the 20th century. And in my opinion, has never fully been resolved, leading to a kind of uneasy position of law and legal science within the panoply of sciences. So my suggestion would be for legal historians to go back to the time around 1900 and to actually figure out how law relates to other disciplines. But I also think that anybody interested in foundational research might benefit from current and contemporary debates in the sociology of knowledge and the theory of science. And I'm curious to hear what you think about that. Am I allowed to ask another?
Yeah, that was such a cool question. I think we should authorize a second.
I tried very hard. My second question is what it might look like, in your opinion, to make doctrine itself the subject of foundational legal research. So what I gathered from some of your responses was that there seems to be, in your opinion, a bifurcation or trifurcation even between the application of law, doctrine, and foundational legal research. But I think that's putting the cart before the horse. That's really begging the question, because I think that the boundaries between application, foundational research, and doctrine are constantly being negotiated. And all 3 are different ways of structuring legal knowledge and structuring legal reality, so that I think that a closer look would be beneficial, because there's no necessary way of bifurcating or trifurcating these three things. And so to make this visible, this contingency, I'd be, first of all, curious to think more about, or to encourage people to think more about what doctrine actually means. All of you mentioned doctrine a couple of times, but I have studied law for many years, and I still don't really know what it means. And I think it would be interesting to apply, for example, an anthropological perspective to that. And then just, this is very short, brief, Professor Engels mentioned that it's necessary to train up a new generation of people who can actually do that kind of work. And maybe you could also speak on the role of legal education reform in encouraging students and offering the time to them to actually take other disciplines and combine them with law in a meaningful way, not just at a later stage. Thank you.
Great. Yeah, so let's turn that rich set of questions from two of our attendees here to the panel.
Let me try as brief an answer as possible to this myriad of questions, because on some level, I think, except for the last one, they all relate. I think there was a time when law was what Marietta says economics is now, which is the meta language, so to speak, within which we discuss all social issues. And in that sense, interdisciplinarity was, so to speak, built into legal discourse. Legal discourse was at the same time sociological discourse, was at the same time philosophical discourse. And the concepts of law were also philosophical concepts, sociological concepts, etc. And that is more or less lost. And so we have not lawyers, not self-confident lawyers, but we've lost that claim of law as being this universal language. In that sense, I would say interdisciplinarity is necessary for foundational research, but it does not have to be between disciplines. It is also possible to recreate within legal discourse some of the inputs from other discourses. Actual interdisciplinarity is, as you all know, surprisingly difficult to achieve. As true interdisciplinarity, as opposed to, someone said interdisciplinarity is sometimes just the lack of discipline, right? You just do what you want and you improvise dilettantly with different things. So a sophisticated way builds knowledge from outside into our legal discourses. But if legal discourse indeed were only to apply existing law, then we'd be replicating what's already there. We wouldn't actually be doing research in that sense. So I would say that kind of interdisciplinarity is necessary. What is also necessary, what Katharina Schmidt mentioned with the sociology of knowledge, is to break that down, a kind of self-reflectiveness, that at the same time in which we research, we observe ourselves doing that research, and that becomes part of the research itself. I think that's true for all foundational research, for all research, and I think it is also true in legal debates. And that means also on the question of what legal doctrine actually is, as she suggests, that's a big question, and where the bifurcation, trifurcation happens. And all of those questions, I think they're built into research. I don't think they always need to be addressed explicitly in order to make progress. But we have to be aware of the contingency of these concepts. We have to be aware of the contingency of any separations that we do, not only within legal research, but also between law as a field of research versus other fields of research. And I think much of what foundational research is to be self-reflective about the way in which all these issues influence and are themselves elements within our research.
Anne Peters.
I would also like to lump the questions together and add just small points to what Ralf just said. So of course, the distinctions and categories, they are in historical and geographic terms contingent, and I think it's not a goal in itself to delineate them clearly. So concerning the second question, under what conditions we can consider law as a science. Of course, in English, we have the additional point that science is reserved for the so-called exact hard sciences. So I would rather say scholarship for the humanities and social science as well. the answer, of course, then depends what concept you have of science, what science means. And there are also different answers have been given through history and in different parts of the world and with regard to different disciplines. I spoke at the beginning, I mentioned the temporal aspect that Aristotle, for example, he thought that scientific findings must be eternal truths. Only then this is scientific, as opposed to just, speaking of law, prudentia or just Rechtskunde or so. And against this claim of eternal truths, there is the dictum of Julius Kirchmann, which was, I think, also alluded to by Marietta Auer yesterday, who says that ein Federstrich des Gesetzgebers und ganze juristische Bibliotheken werden zur Makulatur. And that is, of course, our key problem, namely that all legal analysis is dependent on some givens, namely the law, which can, of course, change. And when the law is changed by parliament or by whoever, then the whole analysis which was done wanders to the trash bin. That's what Kirchmann regretted. But it only wanders into the trash bin if it is conducted as in a totally applied way. If the reflection done is linked exactly to that text of the law, which is then abolished or changed. The findings will not wander into the trash bin if they are on a higher level of abstraction or on a higher level of generality. Then we can still make statements which retain their relevance, even if the letter of the law is changed. And I think that in that sense, also legal scholarship can make discoveries or inventions. If you say that this is also a hallmark of science, to find out something new, then you often read, well, a lawyer cannot invent something new because exactly he or she is tied to the law as a given. But I think that you can find concepts, inventions, which can count as a generation of new knowledge. For example, in my field, the concept of responsibility to protect, which was coined in the aftermath of the genocide in Rwanda. This is, I think, a legal invention, and it's a successful concept which can fulfill useful purposes. It's the idea that state sovereignty comes with a responsibility to protect the population against genocide. It's just a shift of perspective away from the question what a sovereign may do, what are the rights and competences and powers of the sovereign, just to invert it and say, what are the responsibilities? I think this is, it may seem very modest, but this is, I would say, a discovery in law. This is a scientific finding, if you want. Now to the second question of what's doctrine. I think actually the German word dogmatic conveys a little bit better what it is, because dogma, like also theological dogmata, dogma means that yeah, it's like an axiom in a way. So this is a given, and for me, this explains what dogmatic is about. It is legal argumentation about understanding a text, making sense out of a text with various what's called methods, but which are not scholarly methods, but which are techniques for understanding better a text. And the text is the dogma in a way. You have to move inside the system. For example, finding better coherence or exposing contradictions and so on. And I once spoke to a linguist, and he speaking about that, and he said, oh, there is the distinction between lexical sciences and encyclopedic sciences. And I think that dogmatic is a lexical science in the sense that it is completely inside the system of the text. But as we said before, it's basically useless if it does not digest findings from the outside and also observations about what are actually the social issues to which the text reacts, etc.
Christoph Engel has a two-finger comment.
I'd like to come back to this intriguing question. Can we study in a meaningful way doctrine as itself, as a topic for foundational research? I think this is a great project. You seem to come more from the macro perspective, and then you could say this is an institutionalized social practice. We use it as a tool for enculturating the next generation. And we could back this up with lots of observations that if you have your first year students, they have tons of ideas. If you ask the same case for your second year students, they have 3 or so options, no more. So enculturation seems to work extremely well through doctrine. Personally, I would be most interested in adopting an individualistic perspective, or you could also say a decision-making perspective. How is it that the anticipation of having to later report the result of your decision-making in the language of doctrine changes the way how you actually make this decision? This could either be just a constraint perspective. So I happen to know, wait a minute, this is not part of my feasibility set. It could also be, and this is what I personally think is more likely, but we have no evidence thus far, that knowing the doctrinal makeup around you already interacts with this intuitive way of finding a solution to the impossible task. But here all I can say is great research question, and hopefully very soon we will know more. Thank you.
Josef, Drexl, you want to come in?
I don't know whether I can respond to the second question. I would be more interested in this regard, but I can also combine the two. I would not see a fundamental dividing line between dogmatic legal research and fundamental research in law. Interdisciplinarity is certainly a possible criterion, but don't forget being at an interdisciplinary institute, then understanding the law would be fundamental research, or better understanding the law would be fundamental research for the economists. If they do economic research on the effects of the patent system, then they have to know the patent system, right? As we have to understand the economics when we make legal arguments on that law. So interdisciplinarity may capture more appropriately what we are talking about. I was intrigued by the question regarding sociological research. In this regard, maybe let me generalize a bit. What I nowadays advise my PhD students to do is have a very good and convincing research question. And that should interest lawyers, right? It has to have a legal nexus, of course. What a legal research question is, maybe that's yet another debate, but you need to have a question. And then the whole thesis should have the purpose to answer that question. And the next step, of course, is what methodologies will I use? What is my framework of analysis? And there are choices. And maybe then sociological research can be a choice. Why not consider it for certain research questions? I had it once that I supervised somebody who did the habilitation for the habilitation thesis, who had the topic of the research question very simply was, is the private law, private court system capable of solving questions that in the past be allocated to the regulatory bodies, right? So very much an institutional question. And then, of course, the question is, what are the goals? How do I measure that the working of the system is appropriate? And he chose a sociological framework. So the question was not whether a decision is correct or not. He looked at the basic functions of a court system, pacifying societies, providing quick answers, and so on, right? Very fundamental issues for an institution to work for the benefit of society. Whether on a particular legal question, that would be dogmatics, the answer is correct or not, is completely secondary. He actually said it's an evolutionary process and we have to accept it as an evolutionary process, right? And that is sociological research. For me, it was fascinating reading the thesis. He got a lot of criticism when the book came out, right? But more from the dogmatic side. So I think that is innovation in research. Why not do it? So I would, in principle, encourage researchers, especially young researchers, to think more clearly about what the methodologies that they actually want to apply are and what the framework of analysis is. And it's for us as supervisors to advise them whether the choices are good ones or not. But the research then needs to be done by the PhD student.
Thank you. For the very last minutes, I have one last question in the online forum. So I propose the following. We ask Richard Dören to ask his questions, and then every panelist has the chance for a very short summation. And please, either you answer to the question, or if you do, please combine it with your last statement. So Richard Dören, please.
Thanks a lot, Professor Kaiser, and thanks to the panelists for a really nice discussion. I would like to address an issue that has been addressed mainly indirectly so far, I would say, and that is the relevance of scholarship and the related question whether scholarship needs to be relevant. Because as far as I understand, the definition of science is to produce new knowledge, and that knowledge, if I understand correctly, does not have to be relevant in the sense of contributing to solving daily problems or so. And one may say, of course, that as we are working at public institutions who are funded by the taxpayers, our work somehow needs to be relevant in order to justify that we get public money. But I think from this theoretical point of view, it does not have to be relevant. And maybe there's also a difference with regard to foundational research and doctrinal research, because as a doctrinal lawyer or as somebody who did a doctrinal paper, you can always say, well, maybe this legal problem comes up in a week or so in a court proceeding. So maybe you can say something on whether you think that research needs to be relevant. Thanks a lot.
Thank you. So we now have the last summation. Maybe Mr. Drexl, do you want to start?
Mm-hmm. I enormously love the question. It's an excellent one. Actually, to my PhD students, I tell them, please make sure that your question is relevant, right? But that is maybe typical for our institute. If you are a scholar in the field of legal philosophy, it's a completely different perspective. What is relevant today, or what is not relevant today, may become relevant tomorrow. So quite often we don't know. And there's another perspective. Research often has to travel quite a long way, and it has to go through many, many different stages when the relevance is not clear. And finally, the goal still is to narrow it down to relevant questions. That is also what we are doing to a certain extent, that we try to understand technologies and to understand whether what the relevant research questions from a legal perspective are, what really matters in the future. That is very exploratory research that we get together with technical people to better understand the technology. And that at the moment, we don't know. We don't know, and that is, I think, very important, at least at our institute, that we do this. But that is maybe not what you will be able to do in a PhD thesis. So also the vessel you are using is very relevant, or it's very important to decide whether the research has to be relevant now, or whether it may become relevant. All kind of research of this nature has its own justification, I think.
Mr. Engel.
Well, great question, of course. I am not very much concerned if I look at least the legal system in Germany, or the legal academic system in Germany, that we are in danger of becoming more and more irrelevant. Given this historical point in time, rather say where we could open up a few more avenues is opportunities for young scholars who are driven by their curiosity to actually live their dreams. And as they are trained lawyers, I'm very confident that they will not completely go astray, but will want what they do as their work matter, not just for being published in good journals, but for the society that cares about the law. And in that respect, actually, I'm pretty optimistic that the foundations of law in Germany and broadly are not in danger.
Anne Peters.
I think that it is a task of a community, like a state, to give public funding to create a space for academic creativity. So that in a way, the funding is not directly tied to any research outcomes, but because it's exactly the purpose, at least in our value system, where we have academic freedom and we understand academic activity and science as a necessary and important activity for a society, and that we trust that the scholars to choose their own topics and also to decide whether they want to research on something which is seemingly completely irrelevant. But as Josef Drexl said, it may become relevant later, and that's exactly then the scholars themselves, bottom up, which know best. And it is they who have the imagination and creativity. And I think that it's kind of a safe space. So it's inbuilt in our system that there is a safe space for choosing the topics, how irrelevant they may seem. However, I personally think that it is a moral and social responsibility of the researcher to choose topics which he or she deems relevant, but not because I'm paid by taxpayers' money, but because I see it as a, as I said, social, ethical, or moral responsibility for myself. But it may be that the topics are still very, very far away from being applied, or seemingly far away from being applied.
And Ralf Michaels.
Yes, and I think the question, because it helps clarify something about foundational research as well. There's a difference between relevant and useful. I think all research has to be relevant. It has to be relevant, it has to provide society with something that it didn't have before, and that matters. Not all research has to be useful, especially in the sense of being applicable and applied. Not all research has to solve actual problems that we already realize that exist. And as concerns foundational research, maybe I would sharpen that. Useful research in the sense of solving existing problems, in the sense of an instrumental knowledge, that is a knowledge towards resolving specific practical problems, that is confined to that, is not foundational research. That's the old Max Planck saying. but it's also problematic research in the sense that it subjects itself to this kind of instrumental approach to research. The hope that we have in Max Planck is that we are freed to some extent through our generous funding from that instrumental thinking, that instrumental research. And so I think our task is to reject pure applied research. Our task is to reject usefulness in that sense. If we were only useful, we would not be doing foundational research. We're doing foundational research where we create knowledge that is not immediately useful. And that's, I think, what our task is, and that's, I think, what foundational research is in the end.
Well, our time is over, and I want to thank especially the panelists for a great discussion. I benefited a lot from the panel, and I hope the auditorium enjoyed it as much as I did. And I want to thank Russell Miller, who organized everything, and without whom this panel wouldn't be possible. Thank you so much.
Thank you. And thank you, Anna-Bettina Kaiser.
Thank you.